if you die intestate and you have a spouse, the spouse takes all the property. If you have a spouse and kids who are also issue of the spouses, then it's one scenario where the spouse gets $100,000 and then one half of the remainder, and then the rest gets split by the kids. If the kid's not an issue, then it's a different scenario, and it goes all the way down to where you end up having nobody directly basically related to you, and then the remainder of it gets split up between all your remaining heirs.
Are you ready for a successful retirement? We're addressing the topics facing today's retirees. Welcome to Retire with Ryan. Now here's your host, Ryan Morrissey.
Welcome back. This week, I'm continuing my discussion with special guest Edward C. Burt Jr., otherwise known to his friends as Ned. Ned is an attorney licensed in the state of Connecticut and also a probate judge in the state of Connecticut. We're continuing our discussion on how to simplify your probate process and your estate. In case you missed part 1 of my interview with Ned, that was episode 101. You can find a link to that by going to retirewithryan.com. Here's part 2 of my interview with Ned.
You know, I will say that, and just like my legal profession, people obviously, the comments regarding lawyers and the legal profession and so many other things, that I have been practicing law for 40 years. And I tell people I've been very blessed with respect to the other professionals I deal with. You hear stories about, people paying people to represent somebody or getting kickbacks for real estate deals or personal injury cases. I can count on 3 fingers the times I've heard that from people. And believe me, it didn't take 3 seconds for me to end the relationship with them. But I found the overwhelming majority of the people that handle the estate work, certainly in the Hamden-Bethany area, have proven to be the same type of trustworthy people. You do have people that cut corners. You do have people that do things they're not supposed to do. But candidly, that's one of the things that the probate court is there for. So if you as a beneficiary or an heir feel that somebody's not doing something right, you can request a hearing and you can put forth whatever claims you may have with respect to that particular situation.
Sure. That's good to know. And I guess those hearings must happen, right? Or else,
Yeah, we have the hearings. And as so often happens with hearings like that, when somebody is claiming they're entitled to something or somebody is claiming that somebody is going south with something and they raise holy hell over it, when it comes time for the hearing, either they don't show up or they withdraw their complaint. But at times, certainly there's been validation with respect to claims where people have gone south with money, and you try to deal with it as best you can regarding it. And unfortunately, sometimes that happens to be professional people to do that. So you really need to pay attention to your own funds and don't be afraid to ask questions of who gets appointed as executor administrator. You're entitled to do that. And if you're not getting satisfactory answers, you should most certainly file something in the probate court so that the court is aware of it, because otherwise the court's not going to know that you feel somebody's going south with money.
Sure. Getting back to something you said earlier about, I guess it would be dying without a will or dying intestate. I believe, are there laws in Connecticut that dictate who would get your money in that instance?
Yes, they do. Yeah, there's a whole laundry list of what takes place in that particular instance. And somebody dying intestate and filing in the probate court without a last will and testament, becomes more burdensome for the person. It becomes more expensive for the person. And just one example of that is, if you do a last will and testament and you name someone as the executor or executrix, you can actually excuse them from posting a bond. And a bond would be funds to make sure that if an executor ran away with money, the bonding company would get involved and potentially reimburse the estate so that the heirs would not be out money. Most wills excuse bonds. When you do something intestate, you can't excuse the bond unless every single beneficiary or heir signs off on something. So you're already talking about spending more money and it's statutorily mandated. So in my role as a judge, I have no right to excuse that. But, it's always interesting, Ryan. I, refer to this from time to time, but I knew you were going to ask it. So I actually pulled it out. And, if you die intestate and you have a spouse, the spouse takes all the property. If you have a spouse and kids who are also issue of the spouses, then it's one scenario where the spouse gets $100,000 and then one half of the remainder, and then the rest gets split by the kids. If the kid's not an issue, then it's a different scenario, and it goes all the way down to where you end up having nobody directly basically related to you, and then the remainder of it gets split up between all your remaining heirs. So have I had a scenario where Uncle Joe died and had a ton of money and had absolutely no kids, no spouse, parents dead, no brothers, no sisters, and little third-generation nephew, Sammy, out in Indiana, ends up getting $100,000 from an uncle he never met? It's not a bad gig if you're Sammy in Indiana, but
probably not what Uncle Joe wanted, right?
No, I don't think so. Just also just fill in a bit for you with respect to the process itself. Oftentimes, probate will take 6 to 9 months to wrap up. And it takes that long only because you have a person passes away. If there's a will, it's supposed to be filed within 30 days of probate. Then there has to be publication notice in the newspaper, which typically 14 days after the will is filed. There's a 150-day claim period during which people can make claims against the estate. And that's one of the reasons why something gets published in the paper. Certainly, if the person received any state benefits, the state also has to receive notice. And then the fiduciary basically has 60 days after that claim period to respond to the claims. So that's 210 days out. And then an estate tax return is supposed to be filed within 6 months of the date of death. And one of the things with the estate tax return, if you're involved with a family who's had somebody pass away, you really do want somebody to start acting on it shortly, because if there's any estate tax due, you're going to get penalized for not filing on time. And you can ask for extensions. And then you eventually get to a point where what's known as a final accounting and order for distribution is submitted. And again, that 6 to 9 months, I think, is a reasonable time frame for people to guesstimate what it's going to take for a simple estate without any type of objection by parties. You can, during that period of time, do a lot. You can, if the claims process is done, no claims have been made, and somebody wants a distribution, they certainly can ask the administrator or executor to request that from the court. You can attempt to sell a house if there's real estate involved. Most wills will give the executor the right to sell a piece of real estate without seeking probate court approval, which for any of your listeners, if they're drafting or getting drafted simple wills, I would certainly recommend they have their attorney put that in there, because that'll definitely save time. And so they can do all of that while the probate process is running its course. And there's also, Ryan, a streamlined probate process. What I was just describing is basically what's considered a full estate. You can have a streamlined process where the person that passed away, the decedent, does not own any real estate solely, and they have less than $40,000 in assets. If that's the case, then they basically can file a couple of forms in probate to get the wheel turning and basically just zip through the process much more readily. I'm hesitant to say this, but that is something that most people probably could do without professional involvement.
Sure. Yeah. I mean, there's a lot going on with the other process, obviously. A lot of things you're doing.
A lot going on, a lot of moving parts, a lot of time frames to be met, expectations for people with respect to beneficiaries. Just like you said before, if you have an executor and people are upset and there's brothers and sisters involved or whatever, boy, if you have an executor that's trying to do things on their own and they're missing time frames, then it becomes a interesting scenario.
Sure. So regarding the last will and testament, once someone's done that, does that have to be filed with a court, or what's the process with that?
That's a great question. So many people think that when your last will and testament is done, that it's filed down to probate court. It's not, and it doesn't have to be. It gets filed when the person passes away. Technically speaking, in Connecticut, only the original last will and testament can get admitted to the probate court. In the old days, many attorneys held on to the original last wills and testaments, and they held on to them because then when the person passed away, the family had to go back to that attorney, and that attorney then, in turn, would handle the estate work. I've been doing this 40 years. When I first got out, all our early attorney educational seminars were, do not keep the original will. If you keep the original will and you lose it, and there's an estate battle, you better put your malpractice carrier on notice. So I've never kept an original will, but I have also learned that if you lose the original will, a conformed copy can be filed with the probate court. And depending upon the legitimacy of it, you may need testimony from the witnesses or some other proof to establish that that is, in fact, Ryan Morrissey's last will and testament. Ryan Morrissey hasn't changed that last will and testament in the last 5 years and didn't tell anybody he was going to change it. So there can be issues involved in that. I had one case where I think two sisters filed. I don't know if there were 3 and 3. I don't think there were 6 wills between them, but I think there were 5. So one of them had 3 filed. Another one had 2 filed. And then one of them happened to make a videotape of mom, which was really interesting because as the daughter was asking mom questions about what she wanted to do with her estate and had her read one of the wills, mom was hesitating and answering, and the daughter would go, well, mom, that's the last will and testament you want, isn't it? Oh, yes, that's the last will and testament I want. So it was a really great scenario. And again, it's wild what happens when you have somebody just trying to feed you a line of BS with respect to this. And actually, I said to the woman, I said, so you videotape your mom and you had to feed your mom the answers. You had to correct your mom. And then you sent me in the video. You didn't decide you were going to redo it? I mean, oh my God. That was an easy decision to make.
Yeah. So how do you know, in a situation like that where you do get 2 or 3 wills, like which is the valid one?
Sometimes it's hard. Certainly testimony is taken from the witnesses. Testimonies typically taken from the attorney who tested to the will. Then, both parties certainly have the opportunity to bring someone in. If somebody feels that maybe mom had diminished capacity, they certainly can bring in whatever type of evidence, whether that's professional evidence from a doctor or, their own testimony. I do remember one case, I have to tell you, I was surprised and just the opposite. Taking a look at the paperwork, having the preliminary hearings, I was convinced something was amiss. And I have to tell you, after listening to the witnesses who came in to testify and the attorney that testified and listening to the other people who testified, I realized that it was a misconception on my part to think that something was amiss. It was, at least I felt then, that it was appropriate, and I admitted that particular will.
Sure. Okay. So I guess you'd want to have an attorney notarize it, or, that's one of the ways to make sure it's valid.
Yeah, you need 2 witnesses and a notary. Some attorneys, Ryan, actually name themselves as the executor or alternate executor. Again, that was frowned on when I was learning how to do it. When I see that, quite frankly, I don't care for it. If it's a sophisticated matter where there's a trust involved and the attorney may have been named as a trustee or an alternate trustee, I get it. But for most simple wills, it just sort of makes me wonder.
Sure. Yeah. So, I think it's a good point to wrap up here. We've covered a lot. Do you have any final tips for someone to try to simplify the process as best as they can for their family to go through when it comes to probate?
Sure. I definitely think it makes sense for them to go consult with an attorney. If they decide they don't want to move forward because a last will and testament may cost too much, or the documents that they want prepared cost too much, or they're not ready to get into something more sophisticated. But I do think that, going and consulting with an attorney, it makes sense, especially, if you're married, if you have kids, if you have real estate, or if you have a significant amount of money in an account. It just makes good sense to hire the appropriate professional, whether that's someone in your profession as a wealth manager, an insurance person, an attorney. It's good to have those people on board, somebody you can trust and speak to, and somebody's going to tell you, yes, you do need this, or no, you don't need this. And I would urge people to do that. You can Google everything today, as we know, and that goes from anything medical, legal, and financial. If you're a carpenter, hopefully you know what you're doing as a carpenter. If you are a salesperson, which all of us are to a certain degree, I hope you're good at it. If you're a doctor or a nurse or an accountant, again, that's your profession. It's not my profession. If you're going to be talking about making any type of financial investments, or you're talking about doing anything from an estate planning point of view, you're going to want to go to the people that do that. People in your profession, the people in my profession, because we just don't know what we don't know. And, my practice before I became probate court judge, I did next to nothing as far as any type of estate planning with sophisticated trusts and estates. And I have stayed so far away from that in my profession. And people will say, well, you're a lawyer. You should, yeah, I don't know that area. And I don't know what I don't know. And so you really want to get the appropriate professional advice, in my opinion. The probate court clerks are very, very helpful. I'm certainly blessed in Hamden Bethany with Christine Panzo and Melanie and Gail and Karen. They can answer most questions for people. They can't give legal advice. And I think you're going to find that most probate court clerks are very, very helpful to people. So you certainly can start there. But in my estimation, it makes good sense to hire a professional.
Sure. Okay. Yeah, makes sense. All right, Ned. Well, if people want to reach out to you, what would be the best way for someone to do that?
Well, that's interesting, Ryan, because I can't speak to anyone that has a matter pending in Hamden Bethany probate court or who anticipate filing something in Hamden Bethany probate court. Ethically, I'm not supposed to do anything in any probate court, so we stay away from that. But certainly if anybody had any general questions, they could call me at my office, which is 203-248-2182. You may or may not get through my paralegal or my assistant. If you tell them it's a probate matter, you should make sure you tell them that it's a general question and has nothing to do with Hamden or Bethany, or you'll never make it through. And I'd have to disqualify myself from any case if I spoke to someone involved in it.
Yeah, makes sense. All right, awesome. Well, thanks a lot, Ned. Appreciate you coming on.
Ryan, thank you very much. I appreciate you having me. I'm honored to be here on the Morrissey Wealth Management Podcast, and to think that it's your 100th show makes it even more special, but not as special as your 5th wedding anniversary. Congratulations. Very happy for you, your wife, and your beautiful little kids.
Thanks, Ned.
Thanks for listening this week. In case you missed part 1 of my interview with Ned, that's episode 101. You can find it on any major podcast app or going to retirewithryan.com. Also, I greatly would appreciate a review. If you could go to Apple Podcasts and leave me a 5-star review, that'd be greatly appreciated. Have a great week, and I look forward to talking to you next Wednesday. Take care.
You should consult a financial advisor familiar with your specific circumstances before you make any financial decisions. Nothing in this broadcast constitutes a solicitation for the sale or purchase of any securities. Any mention of rates of return are historical or hypothetical in nature and are not a guarantee of future returns. Ryan Morrissey, CFP, is an investment advisor representative of Morrissey Wealth Management, LLC, a registered investment advisor.